The HOA president stood in my living room pointing at my disabled son and said, "People like him don't belong in our neighborhood." 6 months later, she was facing criminal charges and we owned her house. This is how a father-son team took down the most corrupt HOA in Georgia. I never thought I'd be telling this story publicly. My name is Michael, and my son Tyler has cerebral palsy. He's brilliant, graduated with honors from law school despite challenges most people can't imagine. 3 years ago, we moved to what we thought was our dream home in Pinewood Estates, a gated community outside Atlanta. We had no idea we were walking into a nightmare controlled by power-hungry people who'd been terrorizing homeowners for years. But they picked the wrong family to mess with. The first few weeks in our new home were peaceful. The neighbors seemed friendly, bringing welcome gifts and offering to help us settle in. Tyler was excited about his new job at a small law firm specializing in disability rights, and I was enjoying my retirement after 34 years as a high school principal. Our house was perfect for Tyler's needs. Single level, wide doorways, and a gently sloped driveway that made it easier for him to navigate with his wheelchair. The previous owners had already installed grab bars in the bathroom and lowered some of the kitchen counters. It felt like we'd found the perfect place to call home. That all changed on a rainy Tuesday morning when I received a certified letter from the Pinewood Estates Homeowners Association. According to this letter, we were in violation of community guidelines because we had installed a wheelchair ramp at our front entrance without prior approval. The letter stated we would be fined $75 per day until the ramp was removed. I was confused since the ramp had been there when we bought the house. I called the number on the letter and spoke with Diane Hargrove, the HOA president. I politely explained that the ramp was pre-existing and necessary for my son's access to our home. "I understand your situation," she said with fake sympathy in her voice. "But the previous owners never got proper approval for that ramp. It doesn't meet our aesthetic standards. You'll need to remove it and submit plans for something more appropriate." "More appropriate?" I asked. "It's a simple concrete ramp painted to match the house. How is that inappropriate?" "Our community has certain standards," Diane replied coldly. "The slope is too steep, and the material doesn't complement the neighborhood aesthetic. You'll need to submit a formal modification request with architectural drawings, pay the $750 review fee, and wait for board approval before making any changes." I tried explaining that removing the existing ramp would mean Tyler couldn't enter or leave our home independently. When I mentioned the Americans with Disabilities Act, Diane actually laughed. "The ADA doesn't apply to private communities like ours," she said dismissively. "Our covenants supersede those regulations. You should have done your research before purchasing here." That evening I showed the letter to Tyler. Instead of getting upset, he calmly opened his laptop and started researching. After an hour, he looked up with determination in his eyes. "Dad," he said, "she's completely wrong. The Fair Housing Act explicitly protects our right to reasonable modifications for disabilities. And Georgia state law reinforces those protections. We don't need their permission to have a wheelchair ramp." Tyler drafted a response letter citing the relevant laws and sent it to the HOA board. We thought that would resolve the issue. Just a misunderstanding that needed clarification. We couldn't have been more wrong. 3 days later, at 7:30 in the morning, I heard knocking at our door. When I opened it, I found Diane Hargrove standing there with a man she introduced as Victor Reynolds, the HOA's enforcement officer. Without asking permission, they pushed past me into our home. "We're conducting an inspection," Diane announced as if it was perfectly normal to barge into someone's house unannounced. I was too shocked to respond immediately. Victor started taking photos of our entryway, the grab bars in the bathroom, and the lowered kitchen counters. "What are you doing?" I finally demanded. "You can't just enter our home without permission." "Actually, we can," Diane said smugly, pulling out a document. "Section 8.3 of the covenants gives the board right of entry for inspection purposes, and I'm finding numerous unapproved modifications." At this point, Tyler wheeled himself into the living room, having heard the commotion. "Excuse me," he said calmly, "but that covenant section only applies to common areas and exteriors, not private living spaces. You're trespassing." Diane looked at Tyler with such contempt, it made my blood boil. She turned to Victor and said, as if Tyler wasn't even there, "Document everything. Each modification is a separate violation." Then she looked directly at Tyler and said something I'll never forget. "People like you don't belong in Pinewood Estates. This is a community for people who respect rules and standards." I wanted to throw them out physically, but Tyler placed his hand on my arm and shook his head slightly. I understood what he meant. We needed to be strategic, not emotional. After they left, Tyler immediately called the police to report the unauthorized entry. When the officers arrived, they took our statement but seemed hesitant to get involved in what they called a civil HOA dispute. One officer did mention, however, that he'd heard similar complaints about this particular HOA. That afternoon, we received an email from the HOA with an expanded list of violations: the ramp, the grab bars, the kitchen counters, the width of our doorways, and even the height of Tyler's desk in his home office. The total fines now exceeded $4,500, increasing by $375 daily. Tyler spent the entire night reviewing the HOA bylaws, the original community covenants, and Georgia housing laws. By morning, he had discovered something disturbing. The covenants we'd received during closing were dramatically different from what the HOA was now enforcing. "Dad," Tyler said, his voice steady but serious, "I think they've been secretly modifying the covenants without proper homeowner votes. The original documents from when the community was built in 1998 have completely different language than what they provided us, and Georgia law requires a 2/3 majority vote to amend covenants." We decided to attend the next HOA board meeting to address these discrepancies. When we arrived at the community clubhouse, we discovered it wasn't wheelchair accessible. There was a set of 5 steps with no ramp to enter the meeting room. I approached a board member standing outside and explained we needed accommodation. Instead of helping, he smirked and said, "If you can't access the meeting, maybe you should send your complaints in writing." I ended up having to carry Tyler up the steps while another resident brought his wheelchair. It was humiliating for both of us, but Tyler insisted we needed to be present. Once inside, we signed up to speak during the public comment period. When Tyler's name was called, he wheeled himself to the front of the room. Before he could speak, Diane interrupted. "Please keep your comments brief," she said curtly. "We have a full agenda tonight." Tyler nodded politely and began presenting evidence that the covenants had been illegally modified. He explained that the original documents contained specific protections for disability accommodations that were missing from the current version. Halfway through his presentation, Victor stood up and shouted, "This is ridiculous. We have better things to do than listen to complaints from people who moved here without understanding our standards." Several board members nodded in agreement. One woman even whispered loudly, "If they can't handle stairs, they shouldn't live in a quality neighborhood." I was recording everything on my phone, capturing each discriminatory comment. Tyler remained remarkably composed, continuing his presentation despite the hostile interruptions. When his allotted 3 minutes were up, Diane abruptly cut him off mid-sentence. "Thank you for your input," she said dismissively. "Next speaker." As we left the meeting, an elderly couple approached us in the parking lot. They introduced themselves as Robert and Margaret Chen, residents for over 15 years. "We want you to know not everyone here agrees with how the board operates," Robert said quietly, looking around to make sure no one was listening. "They've been using fines and threats to control people for years. Most of us are too afraid to speak up." Margaret added, "They forced the Jenkins family out last year when their daughter needed a therapy pool for her juvenile arthritis. Claimed it violated the water feature restrictions." Over the next few days, more neighbors discreetly contacted us with similar stories. A single mother who'd been fined for having a basketball hoop for her son. An elderly widower threatened with foreclosure because his lawn care service came on the wrong day. A family harassed for having too many Christmas lights during the holidays. Meanwhile, the fines against us kept accumulating. The HOA sent a formal notice of lien, the first step toward foreclosure proceedings. They were literally trying to take our home because we had accessibility modifications. That's when Tyler suggested we take legal action. Not just a complaint or a small claims case. He wanted to file a federal lawsuit against the HOA for violating the Fair Housing Act, the Americans with Disabilities Act, Georgia housing laws, and for fraudulently modifying legal documents. "Are you sure about this?" I asked. "It could get expensive and ugly." Tyler looked at me with fierce determination. "Dad, what they're doing isn't just unfair, it's illegal, and they're doing it to our neighbors who can't fight back. If we don't stop them, who will?" We filed the lawsuit the following week. Tyler insisted on representing us himself, despite offers from colleagues at his firm to help. "This is personal," he explained. "I need to be the one facing them in court." The HOA's response was swift and aggressive. They hired Templeton and Myers, one of Atlanta's most prestigious law firms. Their lead attorney, James Templeton, had a reputation for ruthlessly crushing opposition. Their strategy was obvious: overwhelm us with legal maneuvers and drain our resources before we ever reach trial. They filed motion after motion trying to get our case dismissed. They demanded extensive documentation about Tyler's medical history, our finances, and property records going back decades. They scheduled depositions that lasted all day, clearly trying to exhaust us. What they didn't understand was that Tyler thrived on legal challenges. Every motion they filed, he countered brilliantly. When they claimed the HOA wasn't subject to federal housing laws, Tyler cited 5 precedent cases proving they were. When they argued his modifications decreased property values, he produced market analyses showing accessible homes actually sold for higher prices in our area. The most significant breakthrough came during discovery, when Tyler requested all HOA financial records, board meeting minutes, and covenant amendments for the past 10 years. The HOA attorneys fought this vigorously, claiming it was overly broad and burdensome. After a heated hearing, the judge sided with us, ordering them to produce all requested documents within 30 days. When the records finally arrived, Tyler and I spent a full week going through everything. What we found was shocking: evidence of financial mismanagement, selective enforcement, and outright fraud. "Dad," Tyler said, looking up from his computer at 3 a.m., "they've been changing the covenants without proper homeowner votes. They've been imposing fines that aren't authorized in any document, and the worst part, they've been pocketing most of the money." The financial records showed that of the nearly $1.2 million collected in dues and fines over the past 5 years, less than 25% went to community maintenance or improvements. The rest disappeared into vague administrative expenses or legal consultations, with companies that all trace back to board members or their relatives. We also discovered that Diane Hargrove and Victor Reynolds were business partners in a property management company that had been paid over $300,000 by the HOA. Without disclosing the conflict of interest, they had been effectively paying themselves with homeowners' money. Even more disturbing, we found evidence that they had specifically targeted certain homeowners for enforcement, primarily elderly residents, single women, and families with disabled members. There were internal emails discussing which homes they wanted to turn over to more desirable residents. Armed with this information, Tyler amended our lawsuit to include fraud, embezzlement, racketeering under Georgia's RICO Act, and conspiracy to violate civil rights. He also contacted the other homeowners who had shared their stories with us, many of whom joined our lawsuit, turning it into a class action. The HOA board panicked. They called an emergency executive session and tried to destroy records, but a whistleblower on the Architectural Review Committee tipped us off. Tyler immediately filed for an emergency injunction to preserve all documents, which the judge granted. Diane and her allies then tried a different approach: intimidation. Strange cars began parking outside our house at night. Our mail went missing. Someone spray-painted "Leave" on our garage door. When I installed security cameras, they sent a violation notice claiming the cameras weren't approved. The harassment backfired when Tyler included it in our court filings with video evidence. The judge was so disturbed by their behavior that he issued a restraining order preventing any HOA board member from coming within 100 feet of our property, except for official business. As the case proceeded toward trial, the HOA's attorneys approached us with a settlement offer. They would waive all our fines, approve all reasonable accommodations, and pay $75,000 in damages if we dropped the lawsuit and signed a non-disclosure agreement. Tyler didn't hesitate to reject it. "This was never about money," he told me. "It's about accountability and making sure they can't do this to anyone else." 2 days before the trial was set to begin, something unexpected happened. Victor Reynolds contacted Tyler, asking to meet privately. He was scared and wanted to make a deal. "Diane has been running this scam for nearly a decade," he confessed during our meeting at Tyler's law office. "She handpicks board members who will follow her lead. Anyone who questions her gets targeted until they sell and move." Victor provided internal emails, bank statements, and recordings of private board discussions that confirmed everything we'd suspected and revealed even more corruption. In exchange for immunity, he agreed to testify against Diane and the other board members. The case finally went to court 7 months after we filed. The courtroom was packed with Pinewood Estates residents, local media, and even representatives from housing rights organizations who had heard about the case. The HOA's attorney tried to paint us as troublemakers who wanted special treatment. He argued that the community's property values would plummet if they couldn't maintain strict aesthetic standards. He claimed Tyler was using his disability as leverage to circumvent reasonable regulations. Then came the moment that changed everything. During Tyler's cross-examination, James Templeton tried to undermine his credibility. "Mr. Richards," he said condescendingly, "isn't it true that you've been looking for a fight since you moved in? That this entire lawsuit is an attempt to extort money from hard-working community volunteers?" The courtroom fell silent. Tyler wheeled his chair closer to the stand, looked Templeton directly in the eyes, and spoke clearly into the microphone. "When I was 8 years old," he began, "my doctor told my parents I would never walk again. When I was 14, my high school counselor suggested I shouldn't take advanced classes because the workload would be too stressful for someone in my condition. When I applied to law school, an admissions officer asked if I had considered more suitable career options." Tyler paused, his voice steady and strong. "Throughout my life, people have tried to decide what I can and cannot do. They've attempted to set limitations on my dreams, my abilities, and even where I'm allowed to live. But here's what I've learned. Those limitations exist only in other people's minds." He gestured toward the HOA board members sitting at the defense table. "These people didn't just violate housing laws. They created a system designed to exclude anyone they deemed undesirable. They used their power to decide who belongs in their community and who doesn't. They falsified legal documents, embezzled funds, and punished those who couldn't or wouldn't comply. That's not protecting property values. That's discrimination, fraud, and abuse of power." Tyler's words resonated through the courtroom. Even Templeton seemed momentarily speechless. But what happened next shocked everyone. Diane Hargrove stood up from the defense table and shouted, "This is ridiculous. Our community has standards. We shouldn't have to lower them because some people can't meet them." The judge immediately called for order, but the damage was done. Diane's outburst revealed exactly the discriminatory attitude our lawsuit was fighting against. Several jurors visibly reacted to her words, and I could see from their expressions that they understood exactly what we were up against. From that point, the case unraveled quickly for the HOA. Victor's testimony was devastating, providing insider details of how the board had systematically targeted residents and manipulated financial records. Former board members, afraid of being implicated in the fraud, began turning on each other, with some offering additional testimony in exchange for leniency. The forensic accountant we hired presented evidence showing nearly $800,000 in misappropriated funds over 8 years. The county recorder testified about irregularities in how covenant amendments had been filed without proper homeowner approval. Most powerfully, a parade of Pinewood Estates residents testified about their experiences of harassment, intimidation, and selective enforcement. An elderly widow described being fined because her late husband's medical equipment was visible from the street. A family with a child with autism talked about being cited because their son's sensory garden didn't meet landscaping requirements. As the evidence mounted, several board members approached the prosecutor about plea deals, offering to testify against Diane in exchange for reduced charges. After 2 weeks of testimony, the case went to the jury. They deliberated for less than 5 hours before returning their verdict. The jury found the HOA had violated federal and state housing laws, engaged in discriminatory practices, committed financial fraud, and breached their fiduciary duties to homeowners. They awarded our class action group $4.8 million in damages, with specific provisions for those who had faced disability discrimination. But the judge wasn't finished. In his final ruling, he dissolved the current HOA board, ordered a forensic audit of all financial records going back 10 years, and referred evidence of embezzlement and racketeering to the district attorney's office for criminal prosecution. He also mandated that all HOA meetings must be held in accessible locations, and that the bylaws be amended to explicitly comply with federal accessibility standards. As Diane and the other board members left the courtroom, some residents applauded. I expected to feel triumphant, but mostly I just felt relieved. Tyler, however, was already thinking about the broader implications. "This case creates precedent for HOAs across Georgia," he said as we headed home. "That's the real victory. It will help others facing similar discrimination." The aftermath was swift and far-reaching. 3 weeks later, Diane Hargrove, Victor Reynolds, despite his cooperation, and 4 other board members were arrested on charges of racketeering, fraud, embezzlement, and conspiracy. The forensic audit revealed they had diverted over $1.3 million of HOA funds for personal use over 10 years. Most of our neighbors, who had been intimidated into silence, came by to thank us. Many admitted they'd noticed problems but feared retaliation if they questioned the board. The Chens brought homemade dumplings and shared how they'd almost lost their retirement savings to HOA fines after being cited for planting non-approved flowers. The most meaningful reaction came from Maria Gonzalez, a single mother down the street. Her daughter had muscular dystrophy, and they'd been afraid to install the bathroom modification she needed. "Because of you," Maria told Tyler with tears in her eyes, "Sophia can now have a home that works for her, not against her." A new HOA board was elected, with representation from diverse homeowners, including elderly residents and families with disabilities. They immediately approved a set of transparent, fair bylaws that explicitly protected reasonable accommodations. Tyler was asked to serve as legal counsel during the transition, a position he accepted without payment. As part of the judgment, the court ordered Diane Hargrove to sell her home to pay her portion of the damages. In a twist of irony, we ended up purchasing it at auction for a fraction of its value. We donated it to a non-profit that provides housing for families with disabled members who need temporary accommodation during medical treatments at nearby Atlanta hospitals. The ramp at our front door remained, of course, but it now represented something beyond access to our home. It symbolized standing up against discrimination and the power of knowing your rights. 4 years have passed since that court case. Our neighborhood has transformed into the inclusive community it always should have been. Property values have actually increased by 23%, proving that accessibility and aesthetics aren't mutually exclusive. Tyler's legal career has flourished. He now heads the Housing Rights Division at a major law firm and has helped draft legislation strengthening housing protections at the state level. Our case is taught in several law school courses on housing discrimination and HOA governance. As for the former HOA board, Diane and 3 others were convicted of multiple felonies. She received an 8-year prison sentence and was ordered to pay substantial restitution. The others avoided jail time through plea agreements, but were barred from serving on any community board again. Sometimes I look back at that first letter about our ramp and marvel at how differently things could have gone. If we had given in, if Tyler hadn't known our rights, if we hadn't fought back, not just for ourselves, but for everyone who had been silenced by intimidation and discrimination. What I've learned through this experience is that systems only work when people hold them accountable. Rules are important, but they must serve the community, not control it. And most importantly, everyone deserves a home where they can live with dignity, regardless of their abilities or circumstances. The new sign at the entrance to Pinewood Estates now reads, "A community where everyone belongs." And for the first time since it was built, those words are actually true. Subscribe for more stories about fighting back against corrupt HOAs.